You go. Good. Welcome, everybody. John Legg here again in Chicago. Thank you, Andrea, for being here and helping produce this a series for the high school and middle school levels. Again, one thing, just real quickly to the review again to what our session tonight is on the caucus, this particular area, and which is the nuts and the heart and soul, if you will, of mediation. Is that what's different from other types of dispute resolution is the caucus. Again, initially we had the initial session overview of a mock mediation. Two hats we wear. One is for the general education, if you will, on all things mediation. The other is the tournament format, which we've developed for the high school level and which we will follow in the tournament in November. So the first one gave you a breakdown of the whole big picture. Opening statements was our second session. Opening statements, you recall, from the mediators, co-mediators share it, and then the parties, the advocate and the party, have their opening statements. And the conference, that was the general discussion, everybody sitting at the table, sharing information, getting information, asking questions, venting, hopefully productive conversation, if you will. Not really the initial conference for negotiation yet, just setting the table, setting agendas. Then with the caucus is the subject here today. And when we mentioned conference, after the caucus itself, which we'll describe here in detail today, is the second caucus. You could have more than one, but in our 1 hour sessions, it's difficult to do more than one, if you will. So the second conference, that's when everybody has shared information. They know where they're going. They've reevaluated their positions based upon the new information which they receive either in the caucus or in the conferences. And that's where the negotiation takes place. The final negotiation, if we will. And it's all right, again, in our tournament setting, if parties resolve it, but they should have the end of the story. Some people are just teaching in India the other day. They call them closing statements, traditionally not heard of here in the United States or most places. What I like to say there is, how are you ending the whole session? Where is this going? So shaking hands, very good, everybody. We agree to everything. You don't get any points in tournaments, if you will, in competitions for resolving it. It's the process, the progress you've had made from when you came in the door till that last hour. It could be something to cut it too short here, cut it a little short here. Could be where we're at. We resolve these issues. We haven't. We'll come back, or we're going to go to court. Hopefully not. Always leave the door open. So, and then our next week we will do evaluating cases, how all these parts fit together, a short review, if you will. And how you break down a case, basically mediation preparation, how you prepare and how to teach the students how to prepare for mediation in general and for competition, how to break the case down to the salient facts, and when you have confidential facts, what to do with them. That being said, now today's caucus. Next slide, please, Andrea. Okay, what is the caucus? Again, we've already discussed conference. Conference is a general discussion. All the people are in the room, 6 party. In our tournament settings, 2 mediators, co-mediators, advocate and client on one side, the plaintiff, nominal plaintiffs generally on one side, the nominal defendants on the other party. Again, there could be different designations, but most of the time it's plaintiff defendant, because the party bringing the action would be the plaintiff and the other party would be the defendant. Even though there might be both cross claims, they both might be pursuing claims against the other. We have a nominal party, plaintiff and defendant. So caucus, after the conference is over, now you have a caucus, and that is key benefit of mediation. It's different than other forms. You have pretrial conferences, sometimes if you have cases in court where the judge has all the parties and attorneys. Sometimes it's the attorneys, sometimes the parties either in the chambers in the back, where it's not in the courtroom where everybody in the world can hear what they're saying. That is not confidential. Anything said can and will be used against you, as they say, in a court of law. That judge is not bound to have anything held in conference. Anything there is said is open and it's out there and can be used against you in court as an admission. Distinction here is the mediator. Again, both parties, not against either one. The mediator is key. Again, it's by the source of law, it's mediation, just the general terminology of it. If it's a settlement negotiation, it's confidential, but it's basically contract matters. Sometimes there's laws, different states, countries that provide for the mediation confidentiality, but generally speaking, it is a matter of contract. So when you enter into mediation, you sign an agreement by the both parties, and here's the ground rules. And the mediator sets out the confidentiality, but usually there is an underlying state or local law that provides for the confidentiality also. Caucus is a private meeting with the co-mediators, one advocate-client team. So in our scenario, in person, one set, we'll go into the format of it later, but one party and the advocate and the party leave the room. So now the mediators are sitting where they are and the other parties are sitting there. And now it's a private conversation. The term caucus is a legal term, so it's nice to have the parties in a competition to refer to the terminology of caucus. So it signals that, yes, you know what that is. And then I like to humanize terms also. When the mediator's there, they can put it in terms of this is a private conversation that we're going to have, or a discussion, if you will. We had the big discussion with everybody in the conference. The distinction is now that I'm meeting with the two of you, we're going to have a conversation here to allow confidential discussions, clarified concerns, explore possible options or solutions in a more focused and private setting. I like to say the mediator will get into the role and the sample of what a mediator would say. Basically, you want to find out why this is not resolved. What are the impediments and what do the parties really need? They coming in, there hasn't been discussion so far. After the conference, there's been a good bit of discussion and trading of information. That changes their positions. In light of this new information, do you have any other potential solutions, if you will? The mediator is the guide in the mediation. You're guiding the parties to not so much as a finite destination resolution, but in the right direction. Parties even don't know at this point what it looks like, what the final solution would be for their problem, if you will. So it's more you go in the right direction in the guide, you're guiding them there. What they want when they come in may change. What they have to give initially will change during the course of the mediation after they've had time to think, exchange information, and have the benefit of a skilled mediator guiding them, if you will, toward what possible outcomes there are. Creative solutions. Have you thought about this? No? How about that? This is the need that you have. What other things would satisfy this need? They say they can't provide this. So what else would satisfy that need that you have? Get them thinking, moving forward. Problem to solution, always in that direction, if you will. Next slide, please, Andrea. Yeah, little differences that we went over this last week a little bit. Conference, all the parties, everybody's in the room, everybody has a say. Remember, in mediation, the general mediation sessions, the whole mediation, if you will, still is confidential. However, if you mention something in the conference, you are disclosing that. So that becomes public within the parties to mediation, not public to the rest of the world. Caucus, one party, one mediator. So we have half of the problem is in the room, if you will, the one side of the problem, if you will. Focus aims to foster dialogue in the conference, exchange of information, free, a safe area where parties can communicate. Remember, in negotiations in our American legal system, it's blood sport, as I like to say, it's confrontational. It's designed to prohibit communication, if you will. All the communication is done through strict rules in a court of law or in the pleadings in court. This is less formal, to say the least. Court proceedings inhibit communication, mediation, and negotiation, which all mediations are negotiation, should promote communication between the parties. The freer and safer space it is, the more likely the parties to be able to communicate and not be afraid of disclosing something that will hurt them. So then generally everything is still confidential to the rest of the world. Private discussion is the caucus. That provides for really a candid discussion of what's going on. And parties when they go, they have their posture, like the prize fighters, a day before a fight, the nose to nose, they're like, yeah, okay, I'm going to kill you tomorrow. Everybody puts their big tough face on. That's your pleadings. We're going to win. You're wrong. We're right. You're posturing. Many times the attorneys posture because they're putting on a show for their client. They're trying to earn their keep. And you see that letter my lawyer wrote. They show it to everybody. Well, he's a nasty son of a gun. Some people value that, if you will. So sometimes it's a show. It's for the benefit of the parties. Here in the caucus, parties can let their guard down, show what's really going on. They can explain to you, and a skilled mediator would draw it out of them. Nobody likes to admit weaknesses or lack of a strong case. But in a caucus, when they feel safe and they know that it will not be disclosed to the other party, They can say, you know, what we're really concerned about is our witness moved away. The medical report we have here, it's a second opinion. If we go to court, they're going to find out about it, but this doctor says they're not really sure of what caused their injuries. So they'll admit, if they're candid and trusting of the mediator, that this is a concern that we have. That's why we can't tell them that, because they'll go to court because they think they have a stronger case. But we really want to resolve it here because we can control what happens today as opposed to the uncertainty out the door when we go to court. And again, the uses conference, collective problem solving. That is, for one, information sharing and getting, questioning, probing, refining positions, refining the parties, clarifying their positions and wants and needs, if you will. And the second conference, collective problem solving. If I were to do this, would you be able to do that? Balloons, you call it sometimes. If I were to move my offer up a little bit, what would you give me in return? Would you be able, would you consider to such and such, a privacy, confidentiality agreement? Would you consider that? Okay, now let's refine your argument into trading and bargaining. Caucus strategic for negotiation, addressing sensitive topics. You're not negotiating with the other party at this point. You're discussing how to go about it and what the best way to achieve your goals are. And with the mediator, the interplay with the mediator, he or she can suggest, have you considered this? Have you considered offering a joint statement that says, we go back to your restaurant again, it's the best restaurant in the world. If they gave you more money, would you consider that? You said you want $1 million. Why is that? So you're addressing the topics in its strategy. Now, you've mentioned to me privately that you have this. Do you want me to express that to them when I see them in their caucus, or do you want to mention it when we come back for the next conference? Would you want me to do it? Would you like to do it? And you could suggest, I think that would be the good time. I think it would be better coming from you, the client, as opposed to me, the mediator, giving them that apology. If I apologize for them, it's not gonna, that she feels real bad about doing this. No, I think it would sound better for you to look face to face to tell them A, B, and C. So they can address the issues and strategize how best to present their offers, counter offers in the future, in the next session of the conference. Andrea, next, please. Discussion topics. Again, this is in the private caucus discussion tier. Strengths and weaknesses of the case. Parties are reticent to admit any weaknesses to the other side. The best you can do as a mediator, get them to say, I understand that we feel we have a good case. If you're in a conference, good position to say is yes, acknowledge that there are uncertainties, not weaknesses in the conference, the general conference. Yes, if we go to court, we think we have a really good case. However, as we all know, you're an experienced attorney, so am I. You never know what a judge or jury is going to do. So we value the certainty of a resolution here today in mediation, even though we think we do really well in court. So you're not admitting weaknesses in the general, but admitting the frailties and the uncertainties of all things judiciary in our system. And the certainty to, okay, even if we win, we'd still have to spend a lot of time and money and court costs and lawyer fees. So you realize it's not a weakness, but it's a uncertainty, and it's a bad outcome is certain in some respects, even though you might win the case. So in the caucus here, the different strengths and weaknesses. The mediator, if you just say, what are your weaknesses? It's putting them on their feet already. They're not going to say, well, we have a horrible case here. No, you have to earn it. You tell them about confidentiality. You tell them about strengths, weaknesses, but they're reticent to do it unless you can tell them about trusting you and confidentiality, but you have to act it as well as you just tell them what is going to be on. So you have to incrementally earn that trust. So here's what I'm saying. Always reaffirm that it's confidential. This is between you and I. I need to know why you want some confidential information. They have confidential facts, both parties, and you want to mine that information so you understand what they really need or want, and you want to find out what the other party needs and wants. The mediators in their competitions do not see any of the confidential facts unless and until the parties in the caucus or in the mediation disclose that information. So they go in blind, if you will, as to anything other than the general facts. Everybody has a general facts. Each party has their own confidential facts, which are not disclosed unless they wish to disclose them. Judges see everything, all the general facts and the confidential facts on both sides. So when you're evaluating the competence level or the performance level of the participants, you're looking to say, did they play their cards right? Did they withhold what they should withhold? When it says your boss said, do not tell them ABC, and did they disclose what the confidential facts say that you should, or that would be valuable in negotiation? This is a good bargaining point. When do you play that card? Here's what we can do. We actually can offer more. So you're evaluating, that's the art form, their skill level in the mediation. Needs and wants of the parties. Interest is the term that many people use. It's sort of a nebulous concept. What are your interests? I'm interested in everything. Okay, what do you want? Everybody comes in. Again, I say what you want has no value in negotiation. I want $1 million. Are you going to give it to me just because I really, really want it? Probably not. So why is it you want that? What you have to give has value. Everybody, not everybody, but generally people in negotiations, in court, they have a wish list, and it's like your Santa Claus wish list. It's like, here's everything I want, and they very rarely look at the other side. And that's one of the benefits of mediation, empathy. You really have to see the other side so that both parts can fit together somehow. That's how you get your resolution. Not taking or having a judge order something. Both parties consensually agree, I will give you this in exchange for that. So all the wants and needs of the respective parties ideally fit together, and they don't have to be jumping up and down happy with the resolution necessarily, but it's a resolution that they can accept. So when they leave and reevaluate it that night and the next day, 2 years from now, when they tell their friends and family what happened, they can sell the story. I call it the post-event narrative. Yes, I resolved it. Here's why. If I went to court, I know I could have got more. However, here's why I accepted 50% because I needed it for this, that, whatever. When they leave it, if it's not a mediation and a resolution that's consensual, if they feel it's been forced on them by a mediator, and that's the role of the mediator. That's the balance. That's a neutrality. Settling again, mediator should work for both. It has to be that perception that they're working for both. One party feels the mediator is beating them over the head to try and take the other party's position or offer. They may take it, but they're going to leave with bad taste in their mouth, and eventually that I was forced to do that. That no good. That mediator must have been in cahoots with the other party, or they were too friendly with each other. Somehow it leaves a bad taste, and it's not the ideal way. Does not lead to peacemaking with the parties, and especially if there's a relationship, an ongoing relation, business or personal, they need to have a positive feel or for the resolution that it was done jointly, fairly, that they got whatever they received, they earn by giving. Settlement offers, demands or ranges. Again, let me go back. Confidential fact disclosures. Mediator tries to get information from them. And it also technique is to say, here's why I need this. You don't have to tell me your bottom line. Some people, what's your top line, bottom line? You don't want to put absolutes because there generally aren't any absolutes. And I don't want to know a party's bottom line. Okay, you mentioned 50 was your offer there. Now, is it possible that you have more money if it made sense for you to offer? You're probing them to find out, well, we only have a 50,000 insurance policy. That's all the money. If we pay more, we go bankrupt. So then you know that it's a firm number. Okay, can you do this? Would you consider going more? If they were to move their price up a little more, would you consider coming down a little more to meet them in the middle? So that's where you kind of get a range, is it what they would or wouldn't do. So in your mind, trying to understand what they really need or want, so you know what they're more likely to accept or not when you get a productive second conference when they do the bargaining. So when you do the collective conference later, you can suggest, I think you should explore that a little more. Not saying I think you should take it or to either party, but I think that's a fertile area for both of you to discuss. I've talked to you both. I don't think you're as far off on these numbers as you think you are. I think if you talk to each other, you might find that you might be able to meet in the middle somewhere. So you're encouraging and guiding them to discuss this area. So because in your mind, they're not as far apart as they think. Settlement, but without disclosing, without tipping the hat off like, hey, they've got a lot more money, I think you should ask for more. Then you're working for one party, not the other. Settlement offers, demands, or ranges. You're trying to determine, how about this? Again, some level of expertise. Generally, offers, all things legal should come from the advocate's mouth, if you will, as opposed to the client. The mediators, or judgment influencers, decision influencers, as are the advocates in mediation. The client is the ultimate decision maker. So they have to be the one to, yes, I can accept this. Yes, I will do this. Yes, I will. But they take the advice from their attorneys, first of all. And not really advice, but guidance, if you will, from the mediators. I think that would be, I think they would welcome this offer you mentioned, that you could double your offer. We can, not saying they'll take it, but I think that would be very productive if you presented that to them in the next session here. Deciding what information is confidential or disclosed. Very critical in it. You have to talk the talk, but then walk the walk as far as, okay, you've disclosed some things. And I thank you, always thank you, gratitude. There's very trusting that you put your trust in me. And as I told you before, I will not disclose this, this, this. I think it's more important generally to have your list of things you will disclose, not won't disclose. For one, you don't want to take the list of do not tell the other party ABC, because then you have it on the table and the other party's looking over there and going, oh. So then you would be betraying your trust, if you will, to the other party. You want to be able to say, here, what things would you like me to tell? All the rest I won't tell them, if anything. Or not if I would tell what things are you considering disclosing in this next conference? Or do you want me to do it or you? And you decide who would do it. And then you again, that's reinforcing the confidentiality and the trust. That's where you're building the bond with the parties. If they trust you, again, rapport. You should, bring your personal style to mediation, which should be a conciliatory style, not demanding. I was a judge and this is the best thing. You should do this, and pointing fingers and telling people. You're kind of telling people in some respects, but you're more guiding them in that direction. Next slide, please. Role of the mediator. Again, mediator is the guide. Encourage open, honest dialogue to come to true interests and concerns. So you're telling them what you're a magician performing a trick while you're telling them how you're doing it. Here's what we're going to do. Here's why we're doing it. The role, the media. We're going to have this hopefully productive conference, which exchange information. I understand this could be a little heated here because there's been some things I've read. All this information, there's been the public statements and nasty letters back and forth. So there might be a little bad blood, but it'd only be productive if we disclose it and not get too heated. And can we all agree not to interrupt, not to argue over each other? So you're calming them and setting the ground rules. So when they break the rules, you can call them back. Now, remember when we first started here, we all agreed to be kind to each other and civil. Even though this is a heated matter, even though it really is a big important matter to you, it's not productive unless we all work with each other. So if we need a couple of minutes, let's go to caucus now. So you use those to guide them into when they start going toward the cliff, you pull them back in, you tell them back in here in a nice way. Encourage the dialogue, true interest and concerns. Try not to, especially in the conferences, to put one side on the defensive. So why the heck do you want $1 million there, Joe? That doesn't make sense. Now all of a sudden you're working for the other party. You've evaluated their side and basically devalued their position, if you will, if you become opinionated and judgmental as their opinion. Even if it's the craziest idea you ever heard. You want $50 billion, okay, because your car was stolen. That sounded, who wouldn't want $50 billion? How do you, what is it or why? Oh, because you're just plain mad as heck and they should pay. Okay, well, then it's not really replacing the car. There's some other issue here, right? You feel disrespect. Try and frame things where it's not judgmental, but trying to get them to disclose wants and needs, what their real interests and concern, what really would satisfy your needs here. And parties generally don't have a good position on what really satisfies their needs. Money, money, money. And that's usually the top of the heap. I want a bunch of money and everything else goes away, or I want my job back, or whatever. So they don't really know that there are other creative solutions. And in our legal system is generally not creative whatsoever. It's you get money, you don't get money, you're forced to do something or not do something. You're going to pay a bunch of money to lawyers and court costs, and you have to spend years of your life invested in the problem as opposed to the solution. That's one of the key roles of a mediator. Get the parties to invest in the solution, not the problem. Address the problem, move forward. Some problems don't just get over it. Some things you never get over. The personal matters, personal injuries, divorces. You never get over what the issue, the problem, the crisis. getting past it is the best way to look at it and get the parties to say, is going to be resolved someday. Why not today? Wouldn't you like to walk out of here in 1 hour and having this resolved, not being able to sleep again, being able to go talk, you spend time with your grandchildren, whatever the case may be, as opposed to investing all your, you came in here with 3 file boxes. Wouldn't you want to invest more time into something productive than going over and over and over the problem, the incident that happened? Put them in the right direction. Sure the party all information remains confidential. Explaining the process initially, then when you get to a caucus, first thing you do in the door of a caucus, I suggest, hi, how are you? Sort of general small talk, but again, remember everything that's said here in this caucus is confidential. I don't disclose it to anybody else. I don't disclose anything unless you tell me or instruct me otherwise. And then when you leave the caucus, generally. Now, again, we went over some very important matters. As I see it, you do want to disclose A, B, and C here, correct? Anything else, if you wish to disclose that later, I certainly won't discuss it when I meet with the other party. So generally in the one rule is to, when you get into a caucus, to confidentially, and when you leave confidentially, one of the first things too I suggest doing is saying, well, what's going on here? What are your concerns? Ask questions. Let them talk to you. This is private. And then the client or the attorney can talk. Now, the mediator is free to ask questions to anybody. Generally, judges don't get to talk to the clients unless they're on the stand. So it's a benefit of mediation, especially caucus. You have free exchange. The parties get to play a role. They want to have their side, their story told. They want to have their day in court. This is a day in court, if you will, to them, but it's because there's some official person listening to their side of the story. Not necessarily saying, yes, you're right, but having understanding. They're somewhat validating them. Yes, I can understand it's how you would feel. Who wouldn't feel the way you do if this happened to them? So you're showing empathy, compassion, sympathy. Not too much, but again, it's a professional level of empathy, if you will. Next slide, please. And then format here. Here's our tournament. Again, real world scenarios, there are many ones, but in teaching here, the basic model of mediation, if you will, here's what we do. We have co-mediators. So in the caucus, 2 co-mediators are sitting there. They must conduct at least one meaningful caucus. If it's not 5 minutes, it's really not meaningful. Sometimes people don't manage their time as well as they should. So at the last 2 minutes, they're going, oh, geez, I forgot about that caucus thing. And they go, okay, what any offers? No, okay, boom, let's get back in. So again, it should be meaningful. And the timing should be generally here, because you have a 1 hour limit. It's most productive, in my opinion, is what the co-mediators decide when it takes place, generally taking after their initial conference, because that's where the agenda is determined by the parties. That's where some information is exchanged. They go to caucus right away. It's a waste of time because they haven't had that, what they haven't had before, all the parties in the room freely asking questions, clarifying positions, wants, and needs, a discussion between all the parties. Different here than court. You don't have attorneys questioning other parties, the other attorney's client, unless they're on the stand or at a deposition. And it's very formal rules. You can't say, well, what's going on here? Irrelevant. It's objection. So here it is, an open, free discussion generally. So that should be done before the caucus, because there's new information. They've got the tea kettle boiled off a little. Okay, we're mad as heck about such and such. Okay, I can understand. Get them all to commit at the same table to working toward the resolution, committing to the solution, not the problem, addressing the problem, committing all to work their best efforts in the time that they have to find a solution if they can, and acknowledging the value of the certainty of resolution through this process. Again, here there could be more than one caucus, sometimes a quick one at the end, just for the last, okay, you raised your offer up to this, we raised that. Can I just have a couple seconds with my client? So they come in and discuss it real quick. Timing wise, if they can do that, that's fine. Or they can mock, if you will, a private discussion. They don't have to leave the room. They can talk to their client. Mary, is this, with a piece of paper, does this look good to you? If 5 or 10, it's up to you. Do you want to offer them 10? And the other party goes, yes, we'd take 10 to do the trick. If you give me 10, would you? So you can have that little, at the end, a second private discussion, if you will. That's usually done in these scenarios only to finalize final offers. If I give you 10, will you give me that? Okay, yes or no. Again, when you do this, one team physically leaves the room. Since it's an in-person tournament, and when we do remote tournaments, you just put them in a different waiting room, if you will, from the other parties, but they're gone. And it's important to note when the two parties, normally you start with the plaintiff and their counsel. The two parties are in the room, the other parties physically leave. When they're outside the room, they can discuss between themselves strategy, whatever they want to do, think about the offers, but they cannot discuss anything with anybody else. No coaching, no exchanging information with anybody else. They can talk amongst themselves, but nobody else. No coach comes out there, a parent or somebody say, hey, I think you should do this and do. Anyone in the room stays in the room. So they just the format, so nobody goes out and whispers a couple things in their ear when they're out there. So they go out there, they can talk amongst themselves. That's it. And everybody else stays in the room. Next slide, please. Move this along. Again, here's the layout. Both mediators present, but mediator here. Here's one distinction here. People, students especially, routinely ignore this, not intentionally, but just to get, as it's new to them to do, but we try and reinforce it time and time again, is that here, two mediators you'll see are there, A and B, and they have the advocate client. They're sitting in the room. Now, this is an evaluative process, a competition. So me as a judge, I want to evaluate the one mediator's skill at running a caucus. So what we have here, we have one mediator, mediator A, will there be a designation in the room, this mediator, you conduct this with the plaintiff. And the other one, just if they want to help at the end, they might just say a couple of words, I think you covered it, or perhaps you want to discuss confidentiality. If they forget it, again, build them up, don't work against them, don't steal their show. If the other one party may not be as skilled as the other. So sometimes you get the alpha party comes in and takes it over and say, to impress parties. It's not where we judge down a little bit if you take over the other party's role. If you help them, if they really don't know what they're doing a little bit, you can suggest, perhaps let's not forget that other offer, agenda item 2 that we were going to talk about. Oh yeah, thank you so much. If they tip them off, if you will, tip them to guide them, but otherwise just a comment or two at the end, because it's your time to shine, your time for me to evaluate your skills, mediator A. Next slide. After it is 5 minutes suggested time, in a 1 hour session, you're not going to have too long. If you're there 10, 15 minutes, you're stealing time from the other party. And here we should have room host or others that kind of say, okay, let's move. And it's everybody's responsibility, time management. Primarily the mediators, they manage the show, if you will. However, even if you realize you're in there too short or too long, you might want to say, I think we've been here long enough, Mr. Mediator, Ms. Mediator, so that we should go back in there to have a little further discussion because we're running out of time. Oh yeah, thank you. So they forget about the time oftentimes. That's why I have a mediation outline, time outline, if you will. It's nice to have it. Works when people have it on the table with them because it's a cheat sheet. They go, oh, wait a minute, what time is it here? It's new. The parties are new to this, and the level experience. People are generally new to mediation, if you will, and competition rules, if you will. So again, here the second one, same as before, but the other mediator who was just passive in the first caucus, that's your time to shine. Now you run the show with the other party. And here's one thing too I suggest: when you're fair, balanced, neutral mediator, when you ask the other party, well, what's going on here? What are your concerns? Oftentimes they go for one party and then the next one, they put them on defense. The other party said, you're a no good cheat. What do you have to say to that? Now they're like, what? Wait a minute. Ask them the same thing, because you're trying, as a mediator, you're trying to say, what's the obstruct? Is there a party who's the obstructionist here? That why isn't this done? What is it that's not keeping this to mesh? It makes sense to me that you parties should resolve this matter. So what's in your head there? What's in your mind and head here? What can I learn from you? And everybody's trying to learn. What can I learn from you? The information that you haven't seen, that confidential fact. You want to mine some information. So now in your mind, you can say, here's the path that they should all be on, because that'll satisfy your needs, your interests, your wants, and happily ever after, hopefully. So you're guiding them now. So do the same thing for them. Then if there's information to disclose from the other party, they wanted me to tell you this. I do have some information. However, I want to do the same thing I did for them. I want to ask you, what's going on? What are your concerns? Have you learned anything else here? Do you have any change of positions? What do you think would move this along toward resolution? Next slide, please. No questions, easy enough. So that covers it in a nutshell, if you will. Again, the two hats we're wearing. One is general information, all things mediation. One, the tournament format, which we can cover a little next week, kind of all the pieces of the puzzle and the timeline, and we'll review the case itself. Any questions? I see the chat. Do we have anything in there, Andrea? You want to filter them?
I don't see anything in the chat just yet.
Okay. And anybody just turn your microphone on and say anything you wish if you have any concerns. If some of this is overlap from the general overview and all the different parts to mediation. And then at this point, we have all the different parts and how they mesh. And next week too, we'll do the breakdown of a case. It's how to, and again, it's basically mediation preparation. So we'll shorten down a mediation outline, which I have to make it more usable, if you will, from the high school level. It is how to prepare and how to refine not only what you want, but to anticipate the wants and needs of the other party. And that's the interplay of the empathy. Normally, you're trying to beat the other side in court. It's a blood sport. It's competitive. It's not pretty. It's dysfunctional in many respects, but it's better than most countries, quite frankly, because at least there is a format for redress of wrongs. However, the benefit here is that the parties can create their creative solutions and resolve it. You're unlimited in your possible resolutions. So here's why empathy is good, because you have to be concerned with what will get the other party to agree to giving me or doing this. So that's where it's not what you want. You have to look at, what do I have to give that they want? You want to know what they want. And if they want it, you're going to pay for it. You're going to pay in the exchange, in the negotiation. That's the bargaining. So you're really concerned, not only because you want to be a good human being and everything's good and you care about everybody, that's nice, but it's useful to you to get to what's truly best for you if you can put all the pieces together to give them what they want, as long as you get what makes you whole. And that's the art of, I call it purposeful negotiation and mediation.